Representative Srinivasan of the 31st. You have the floor, sir.
Good evening, Mr. Speaker.
Good evening, sir.
Thank you. In 2005, by a statute, the Certificate of Merit was strengthened. There's a reason why the Certificate of Merit was strengthened back then. The medical malpractice claims was escalating. The annual increases in medical malpractice insurance was greater than 90%. This increase in the medical malpractice premiums was ultimately passed on, as you know. Direct medicine, defensive medicine, a combination of various factors, bringing up the cost significantly to you, me, and everyone, the average person who is seeking medical help. A lot of physicians, for various reasons, stop practicing certain parts of their specialty. I'm sure you know that a lot of obstetricians and gynecologists decided to practice the gynecological part of their practice because they could not afford to be in the business, in the healthcare situation of delivering babies. A sad state of affairs. And all of that resulted in strengthening a significant improvement in our Certificate of Merit, and that is what we are discussing here today. In this legislation back in 2005, the Certificate of Merit statute required that a plaintiff first obtain a written opinion by a similar healthcare provider before he or she files a lawsuit. So the plaintiff had to obtain a written opinion of a similar healthcare provider. This definition of a similar healthcare provider was well known to the legal community. And that term has been in existence not for the past year or two, much more than that. It is easy, it is simple to understand. If a physician is board certified in one specialty, a similar healthcare provider is someone who is board certified in the same specialty. A person who's board certified in one specialty, the similar care provider has to be in the same specialty and board certified as well. When we strengthened this back in 2005, things are working. We are doing well in Connecticut from this particular angle. We have a lot of other areas of issues of concern with healthcare. No question about that. The costs, the access, major hurdles we are still facing day in and day out. The last thing we want to do is increase the difficulties, increase the hurdles, and that is what we are going to be doing by diluting this Certificate of Merit. And the reason for that is the Supreme Court understood very clearly who is a similar physician and upheld the decisions. The result is many, many non-meritorious claims, actions, did not end up in litigation. Yes, a case was made. There was not enough teeth in that particular case. The case, therefore, could not proceed further, so that was the end of that story. Just a case of point with Plant versus Hungerfield Hospital. The plaintiff's attorney sued the hospital, a psychiatrist, a licensed crisis worker, and 2 emergency room physicians. All of them were brought up in this lawsuit against the hospital and the hospital employees, claiming that negligent care was the reason for this particular claim for mental illness. The expert witness in this case on whom the attorney relied was a retired nurse who was a former client of the attorney. She had worked for 20 years in the nursing field. And she was a phenomenal nurse, did extremely well in what she was doing, what she was trained to do, but she did not have expertise in treating the mentally ill. Neither do I. I'm not trained in that particular field. Whether one is a physician, one is a nurse, one is an APRN, it does not matter if you're not trained in that particular specialty. The Supreme Court agreed that that attorney's conduct was blatant, egregious, and did not allow that lawsuit to proceed further. You can just imagine if this lawsuit was allowed to go further. I'm just giving one example of the lawsuits that are filed which do not have the merit, but take away, sap away our energy, sap away our resources, and are a major, major financial burden. And that financial burden is not only to the hospital, is not only to the physician, it is to everyone, because ultimately it will come down to you, me, and everyone in one way or the other. The biggest concern, and I'm a big champion of this, is that, is it possible through this legal maneuvering of certificate of merit, through the attorneys and through for requirements which are very difficult to obtain, even if we were to make a case for that, is it possible here in Connecticut for a meritorious case not to have his or her day in court? And the answer is very simple. Absolutely no. Absolutely no. Just because the certificate of merit has not allowed the case to go forward, does not have any limitations at all for that person, for that patient, go into a court and ask for a full trial. So this dismissal that happens with a certificate of merit still will enable, if needed, if the plaintiff felt that it was inappropriate, it was not right, and they need their day in court, they need to be heard, they can still be heard because they can refile the lawsuit. And that's important for all of us to know, that just because a certificate of merit does not allow them to proceed further, it is not the end of the story. Yes, if they have a story strong enough, if they feel convinced, the plaintiff feels convinced that a major error was occurred, that he or she did not get her day in court, did not have justice, they can apply and refile the lawsuit. This patient has a right to refile for 1 year after the dismissal to get an opinion from a similar healthcare provider. So there is no compromise here that on the one hand, we want to contain costs, we want to keep the malpractice premiums low, we want to keep healthcare accessible, but are we going to do that on the backs of not giving a person his or her due date in court? And the answer is no. The certificate of merit is one way to eliminate, to flush out those irritating, non-meritorious cases that come up over and over again. But when a person has a case, and there are bound to be, everybody here is human. Making mistakes is part of what we all are. We're all human beings. None of us are God. And so when a mistake does occur, unfortunately, and when it does, can the patient, in spite of being denied at the certificate of merit, take it further and go for a trial? The answer is absolutely yes. So none of us need to feel, by supporting the certificate of merit as it is and not accepting the amendment tonight, that we are going to go back to our constituent and say that I did not give you your day in court. I took away your day in court. And the answer is absolutely no. They can go for a trial. They can go for a trial a whole year, even after this has been dismissed with the appropriate certificate of merit. Tonight, we're going to make a major decision in the direction of healthcare. How our physicians in the state of Connecticut, our hospitals, our emergency rooms, how are they all going to function when we are taken away from them this protection of a claim that has no merit at all, that is not able to stand, and that is why it has been thrown out of court. And as I've said again, the most important thing to me and to each and every one of you is that if a mistake did occur, that there is an opportunity. Doors are not closed. Far from that, they can all go and get a full trial. And earlier in the conversation, our ranking member did talk or bring about a trial case. And that trial is not excluded just because the certificate of merit did not meet the requirements. Through you, Mr. Speaker, a few questions to the distinguished chair of the Judiciary Committee.
Please proceed, sir.
Thank you, sir. Through you, Mr. Speaker, in lines 12 to 15 on this amended bill, it says the attorney filing the action engage in reasonable efforts to obtain a written opinion from a similar healthcare provider. Reasonable efforts to obtain opinion from a reasonable healthcare provider. Through you, Mr. Speaker, is the intent of this language that the attorney first make a reasonable effort to obtain a report from a similar healthcare provider so that he or she can review the case. Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, yes.
Representative Srinivasan.
And through you, Mr. Speaker, only if the attorney is unable to find a similar healthcare provider after making reasonable efforts, is she then only allowed to look for a non-similar healthcare provider? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, if the certificate of merit is provided by a healthcare provider who is not under that definition of similar healthcare provider, then the plaintiff in its certificate of merit would need to state the efforts that they made to obtain a certificate from one who is defined as a similar healthcare provider.
Representative Srinivasan.
Thank you, Mr. Speaker. Through you, Mr. Speaker, what constitutes a reasonable effort for the attorney to have gone through before he or she chooses to go with a non-similar healthcare provider? Through you, Mr. Speaker.
Representative Fox.
Thank you, Mr. Speaker. Reasonable efforts would be ones that are determined by the judge who is making this determination if it were contested. But efforts to obtain a certificate of merit from a similar healthcare provider, I believe, would include the number of similar healthcare providers who are potentially contacted to serve as to provide their certificate of merit, the reasons why they declined to do so, amongst other reasons potentially that the judge could determine.
Representative Srinivasan.
Through you, Mr. Speaker, how is that judge supposed to determine that a reasonable effort was made by the plaintiff's attorney to go and look for a similar healthcare provider? Through you, Mr. Speaker.
Representative Fox.
It would be set out, excuse me, it would be set out in the initial filing of the complaint and the documents that are attached.
Representative Srinivasan.
Through you, Mr. Speaker, in the current version, lines 17 to 22, an attorney is required to sign a certificate that is attached to the complaint stating that the attorney engaged in a reasonable inquiry that gave rise to a good faith belief for suing each of the named defendant. Through you, Mr. Speaker, the new language in lines 12 to 15 required the attorney to have a reasonable inquiry. How are we to know? How is the judge to know? How is the defendant to know that this attorney has gone out and made a reasonable effort to obtain the affidavit from a similar healthcare provider?
Representative Fox.
Thank you, Mr. Speaker. The attorney would have to assert that they made these efforts, and they would have to detail the efforts that they made.
Representative Srinivasan.
Thank you, Mr. Speaker. Through you, Mr. Speaker, details have to be made. And I would appreciate, through you, Mr. Speaker, if we could elaborate on what those details are, what those requirements are, that the attorney, in good faith, went out all of his way to make sure that he or she was able to get a similar healthcare provider. What has to be done so that it is reasonable? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, it would include, first of all, as I stated earlier, it's a determination to be made by the judge who's being asked to address the issue. But my understanding of reasonable efforts would mean that the plaintiff and/or his or her attorney should seek out similar healthcare providers in the area to provide a certificate of merit in the specific case.
Representative Srinivasan.
Through you, Mr. Speaker, the requirement, through you, Mr. Speaker, with the requirement to get to a similar healthcare provider, is it enough for the plaintiff's attorney to say, I made a reasonable effort, I did the best that I could not come up with anybody, no names, I could not find anybody in Connecticut or anywhere in the United States in that same category specialty physician? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, I believe the plaintiff and/or his or her attorney should make reasonable efforts. That would include contacting and reaching out to similar healthcare providers. I would think that they would want to include the number of similar healthcare providers they attempted to contact. In order to say how many, it is somewhat difficult because we're talking about a whole range of potential claims that can be made, and some areas may have a number of similar healthcare providers in the area, some may have very few.
Representative Srinivasan.
Through you, Mr. Speaker, line 37. The bill provides that the letter must include information as to whether the person writing the opinion is board certified in a related specialty. Through you, Mr. Speaker, if the physician who is being sued for malpractice, if he or she is a specialist, is it necessary that the person offering the opinion, is it required of that person that he or she should also be board certified in a related specialty? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, no, it doesn't say that.
Representative Srinivasan.
Through you, Mr. Speaker, so the person sued is a board certified physician, and we have gone out, the plaintiff's lawyer has gone out, made a reasonable attempt to go through a similar specialty physician, did not get one, and now goes to a related specialty, not even the same specialty, a related specialty of a physician who does not even need to be board certified. That is what we are dropping the requirement here. From a physician to a physician who is in the same specialty, both certified, we are now going to a related specialty, and even that related specialty physician does not have to be both certified. Am I correct in that, through you, Mr. Speaker?
Representative Fox.
Thank you, Mr. Speaker. Through you, what the physician does have to be is they must possess sufficient training, knowledge, and experience in the specific care, treatment, or diagnosis at issue in the complaint within a 5-year period before the incident, and would be able to testify as an expert as to the standard of care as to each defendant to whom the expert has issued an opinion. Also, it states that if the physician providing the certificate of merit has any board certifications, those also must be set out. If it's a board certification or related specialty or in a license to practice medicine, that also must be set out in the certificate of merit.
Representative Srinivasan.
Thank you, Mr. Speaker. I do thank the good chairman for that description of the person who could be a witness here. But my concern is, under what circumstances, through you, Mr. Speaker, a person who's not both certified in a related specialty, how could she or he qualify to bring a complaint against somebody in a different specialty altogether, and also both certified in that specialty? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, they would have to possess sufficient training, knowledge, and experience in that area within the last 5 years, and so that would enable them to testify as an expert at trial.
Representative Srinivasan.
Thank you, Mr. Speaker. Through you, Mr. Speaker, allowing a person who's not both certified in the same specialty and now even dropping it down to a related specialty, will it not, through you, Mr. Speaker, offer an opportunity here for us, unfortunately, to file a long list of meritless lawsuits? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, no.
Representative Srinivasan.
Through you, Mr. Speaker, the proponent of the bill had alluded to this in his summary at the onset of this discussion, and we were informed that the burden of proof of showing of the anonymous person who writes this expert opinion, that name of that person, through you, Mr. Speaker, I know it's old statute, but just for our own clarification, it is not new language, I'm well aware of that, is that still to be expunged? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, yes.
Representative Srinivasan.
So if I am clear on this, we have the case written up against this physician by a related specialty, by a person who may not even be both certified, and that person's name, his or her name, is not even known because that name is expunged. Am I right? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, yes, the name is expunged.
Through you, Mr.
Representative Srinivasan.
I'm sorry. Through you, Mr. Speaker, I appreciate that. Thank you very much. Through you, Mr. Speaker, when the name is expunged, how is the judge to know as to who has been the person who has given us this information? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, the judge does not know the identity of the individual. However, the judge knows the qualifications of the individual, the experience of the individual, and the individual's opinion, the training and experience by which that individual would base their opinion.
Representative Srinivasan.
Through you, Mr. Speaker, so the judge does not have the name of the person. The name is expunged, as it is very clear. But the judge has enough information saying that this person in a in a similar specialty, non-board certified physician, has all the expertise, has the background, and has the training. Through you, Mr. Speaker, how is it that this anonymous person, this anonymous expert, is allowed to give all of this information, which is one-sided? Because all that is presented is from the plaintiff's point of view that this particular person has the adequate qualifications, name is expunged. Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, I'm sorry, I'm not sure I got the question. If the representative could just please rephrase the question. I'm sorry, I was listening, I'm just not quite sure I got what you wanted me to answer.
Representative Srinivasan.
It'll be my pleasure. Through you, Mr. Speaker, the plaintiff's lawyer and the judge have an idea as to who has written this certificate of merit. And we do not know at all the defendant as to whether the opinion that was arrived at, is there an opportunity for the defendant to also look at the requirements and the basis of the training of the person who has written this certificate of merit? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, that would be set out in the certificate of merit. So yes, and the defendant would certainly have a copy of that.
Representative Srinivasan.
Through you, Mr. Speaker, what is the purpose? What is the purpose to continue to expunge the name of the person who is the expert witness? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, first of all, it's existing law.
Right.
However, and I should also point out, this is the only type of case that I'm aware of where this type of document is required before a case may proceed. But the expungement of the name was one that was initially part of this Public Act when it became law, and it continues to be so. The purpose for the expungement of the name, I believe, may be that certain medical professionals may not want their names to be known.
Representative Srinivasan.
Thank you, Mr. Speaker. And I do want to thank the chairman for discussing the expungement component, even though it is not new language and it is already existing language. Thank you. I definitely want to thank the chairman for that. The chairman brought up a very important point, that the physician does not want his or her name known, and that is why the name is expunged. But by and large, when we go for an expert opinion, it is not restricted that the physician needs to be in the state of Connecticut. Can the physician who is writing the certificate, can he or she be from any part of this country at all? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, it is not restricted to Connecticut.
Representative Srinivasan.
Through you, Mr. Speaker, I can hence understand why the name had to be expunged, because a physician practicing in our state may hesitate, may restrict from making some comments because it is against a colleague, somebody in their own profession. But we just heard that that name does not have to be, that physician does not have to be from Connecticut at all. It can be from anywhere. And I do not think that any physician across the country will have any hesitation in coming up with his or her opinion with a name attached, because he or she can stand behind what her comments or her constructive thoughts have been in that particular case.
Representative Fox.
I'm not sure if there was a question there. Through you, Mr. Speaker.
Representative
No,
Srinivasan.
there was no question there. So, Mr. Chairman Fox is definitely right. There was no question there. Through you, Mr. Speaker, there is a question now in lines 76 to 81. And we are now dealing with new language. prohibits a judge from dismissing a lawsuit when an attorney fails to comply with the statute unless the only time that he can dismiss the case is if he or she has not even bothered to get a written opinion. Is that right? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, the judge may dismiss the case if there's no certificate of merit attached or if the plaintiff has not remedied the failure to provide an adequate certificate of merit within 45 days.
Representative Srinivasan.
Thank you, Mr. Speaker. So through you, Mr. Speaker, so if there was no written opinion attached to the application at all, the judge can or the judge must dismiss that case. Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, the language says no such action may be dismissed unless the claimant has failed to attach a copy of a written opinion or has failed to comply within a single 45-day period after being ordered to do so by the court.
Representative Srinivasan.
So through you, Mr. Speaker, the first time around, there is no written report at all. Even in that situation, even in that scenario, and we will get back to an inappropriate statement in a minute, but if there's no statement attached at all, through you, Mr. Speaker, does the judge have to dismiss the case, or can we have an extension? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, the intent would be that the case be dismissed.
Representative Srinivasan.
Thank you, Mr. Speaker. Getting to an opinion that may be defective as decided by the judge, what then will the judge have to do in that particular case? Through you, Mr. Speaker.
Representative Fox.
The judge would issue an order stating that the plaintiff has 45 days to provide a adequate certificate of merit.
Representative Srinivasan.
Through you, Mr. Speaker, the first time it was submitted, the attorney was not even aware that a certificate an opinion has to be obtained before the certificate. And in that case, we were told that he could dismiss the case. And now, when what is written is not adequate at all, we are now not saying, the judge is now not saying that the case is dismissed, but does he the plaintiff's lawyer, get an automatic 45-day extension? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, if the court determines that the certificate of merit is insufficient and the court issues an order saying so, the plaintiff would have 45 days from the date of the order to present a sufficient certificate of merit, or the case would be dismissed.
Representative Srinivasan.
Through you, Mr. Speaker, has there even been ever a single case of a patient whose meritorious lawsuit claim was deprived from having his or her day in court just because we have this certificate of merit? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, yes.
Representative Srinivasan.
And through you, Mr. Speaker, and the reason for not getting an opportunity to go for a trial has been through you, Mr. Speaker.
Representative Fox.
Thank you, Mr. Speaker. Through you, because the plaintiff did not attach a certificate of merit that was provided by a similar health care provider.
Representative Srinivasan.
Through you, Mr. Speaker, in that situation where the certificate of merit was not attached and the judge did not allow that case to proceed further, through you, Mr. Speaker, has that taken away the ability or the capacity of the plaintiff and the lawyers to go to a regular trial? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, when the case is dismissed, they are not able to go to trial.
Representative Srinivasan.
Through you, Mr. Speaker, I beg to disagree with that, with our esteemed chairman, because I feel, and definitely something that we can check into, is that even if the case is dismissed on grounds that the certificate of merit did not meet up, that will not prevent that patient, will not prevent that person from seeking his or her day in court through the proper channels and within 1 year of the certificate of merit being denied. Through you, Mr. Speaker, can that person go to a trial in a regular court within that statute period of 1 year? Through you, Mr. Speaker.
Representative Fox.
All right. Through you, Mr. Speaker, and I heard the representative's initial comments when he discussed this 1 year period, and I have to say that I completely disagree. What the representative is referring to is the accidental failure of suit statute. Right. The accidental failure of suit statute is one that is rarely used. It's one that attorneys and their clients avoid, and it's one that is being touted by the opponents of this legislation as something that is very easy to achieve and one that can be used by any plaintiff in any case. That is not correct. What can happen is you can seek an accidental failure of suit statute if, after several years, you get to the Supreme Court level and the Supreme Court has dismissed your case or not found a way to attempt to interpret the language under the current bill to reinstate the case. If the case is dismissed by the Supreme Court at that point, then perhaps 3, 4, 5 years later, you can then proceed under the accidental failure of suit statute, but in many instances, you would not be able to do so. So that 1 year statute of limitations is just wrong.
Representative Srinivasan.
Through you, Mr. Speaker, is it not true that in the Bennett versus the New Milford Hospital case, when the case was dropped and was not allowed to proceed further, the plaintiff in Bennett is allowed to refile? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, what you can seek an extension of the statute of limitations pursuant to the accidental failure of suit statute. But I believe any attorney, including ones in this chamber, would say that is an absolutely last resort and one that you would seek to avoid.
Representative Srinivasan.
Through you, Mr. Speaker, when we are looking at the qualifications of a healthcare provider, is it possible in a scenario of the plaintiff going after an anesthesiologist? Is it possible in this scenario that we are talking about here this evening, an anesthetist, a nurse anesthetist, would be able to file the certificate of merit? Through you, Mr. Speaker.
Representative Fox.
Thank you, Mr. Speaker. I'm sorry, was the comparison, was it an anesthesiologist and an anesthesist? I'm sorry.
Right.
Representative Srinivasan.
Yes, sir. Between an anesthesiologist and a nurse anesthetist. Yes, Mr. Speaker, through you. Right. Anesthetist.
I think I could.
Representative Fox.
Through you, Mr. Speaker, rather than necessarily get into the terminology, a nurse would not be able to file a certificate of merit regarding the standard of care of a physician, and in any instance. And the example that the representative gave during his initial comments, where the case was dismissed, and in that instance, the certificate of merit had been filed by a nurse claiming a breach of the standard of care of a physician, was one that was dismissed, and in my opinion was properly dismissed, and was why we continue to have the certificate of merit to avoid those types of frivolous claims.
Representative Srinivasan.
Through you, Mr. Speaker, I do want to thank the proponent of the bill for his comments, and I appreciate that very much. Ladies and gentlemen, we are here today deciding on something very crucial, very important for our residents, for the residents here in Connecticut. We are not taking anything away from a person who could have been injured, who even has been injured. There will be the appropriate day in court. There will be a day when that he or she can take the necessary steps against the healthcare provider in that scenario. But what we are changing, the landscape here that we are changing, is this frivolous lawsuits. The lawsuits that have no merit at all, but they are able to go through because we are lowering the bar. We have a good bar. We have a fair, consistent system where patients can, where the plaintiff can get his or her day in court if there is a reason for that. But when that reason does not exist, when you have these frivolous claims, what will happen, as it used to? Why did we have this change in the certificate of merit several years ago? Because the practice of medicine here was extremely difficult in the climate. What we are doing today is attempting to go back to those days. We always say the good old days, but here it's not the good old days. When we move back and we lower the bar, what is going to happen is the tragedy that we saw and averted. It is this same legislation that averted that tragedy by adding this particular component to the certificate of merit. And now we come back here, 10 years down the line, or 8 years after, with a system that is working. And that is the part that I'm not able to understand in this bill at all. We are here because people come to us and say, we have a problem, we have a situation. We talked about the veterans, how their tombstones were being attacked. And that is why we had to make changes and make the appropriate changes, whether it be fines or some form of punishment. But here this evening, we are looking at a system that is working, a system that is not broken. And we have not had a whole slew of complaints from patients saying that they are not able to have their day in court. By moving this in this direction, our access will definitely be reduced, significantly reduced. And the equal concern is the cost of health care. I do not think anybody here in this room will argue about the fact that health care is reasonable. It is not reasonable at all. It is, in some cases, unaffordable. And here we are, the richest nation on the face of the earth, and we have so many people that cannot get medical attention. And by lowering the standard, you are going to make it even more difficult on two fronts. A, the access, the availability. What good does it do if you have the best insurance on paper and you're not able to get somebody, you're not able to go to somebody because that person, he or she, is no longer here in the state? That is the first concern for each and every one of us as we press this button tonight. And the other concern is the cost. We know, I do not need to go into details about the expense of defensive medicine. And that defensive medicine's cost has gone up because of our culture, because how easily we go and say, oh, something did not go right for me, and it is, by and large, a frivolous claim. So what we're trying to do is keep those frivolous claims out, keep access in so that it becomes an affordable situation. We are there. Right now, we have a system that is working, and what we are trying to do is try to break the system here. Thank you, Mr. Speaker.
Thank you, Representative.